my watch this side. My watch shows that we have so far used 11 minutes. So I think it is the right time we started. So to catch up with time. Once again, good evening and welcome to our Upustu ProDev Hour. And thank you for joining us, always in this continuous professional development, in the empowerment and the regular updates from the union. Without wasting a lot of time, I wish to invite one of us to take us through a short prayer as we head on to the package of the day, which we shall digest and break down after the prayer. I'm seeing Mr. Paul. Mr. Paul, can you hear me? If you're able to hear me, you may lead us through a short prayer. Mr. Mijuka Paul, are you there? Mr. Rogers, am I audible that side?
Yes.
Okay. If Mr. Mijuka Paul is not able to make it, Harriet, are you there? You could lead us through an opening prayer. The network seems to be unstable that side. Allow me to take on the chance to lead us through an opening prayer. That we proceed. Sorry? Mr. Opus, are you leading us?
All right, let us pray.
Okay.
Father in heaven, we want to thank you for this wonderful time that you have again brought us together. We thank you for your hand of protection and guidance in all that you are able to do for this country, Uganda. Here we are once again, O King of Glory, as a team of Ups2, going to discuss issues that are very important in our families. We want to call upon your guidance and Holy Spirit that, Lord, as we speak, may you inspire us with knowledge and wisdom to understand so that we benefit as your people. Father, as I pray, I want to commit the discussants, our presenters, and everyone who is taking part in controlling and organizing this. All the attendants of King of Glory want to ask for guidance. I ask all this in the name of your Son, Jesus Christ.
Amen. Amen. Thank
Amen.
you so much, Mr. Kokas Apus, for that wonderful brief prayer. And I believe God is with us in this session of today.
You're
after
welcome.
Having that wonderful prayer. Yeah, so members, the team on board as others join us, as we are reminded that always, as we push to, we have the task of ensuring we have these sessions for the purpose of our continuous professional development, our empowerment on legal aspects, certainly we handle those issues that affect us at our work and in our lives and families. Also giving us updates on union engagements and others. Whenever you miss out these sessions, you can always access them on our YouTube channel, which is the Upustu YouTube channel. Remember to keep your mics in mute so that we have an audible and a controlled environment. And also, if you have any questions, you don't hesitate to put them in the chat so that they will be responded to at the end of the session. And in case you have a concern after the session, feel free to raise your hand using the raise hand feature somewhere down there on your gadgets. So members, in these minutes, we are going to engage on some very important aspect involving the family law. And we are glad to host our guest speaker today, Mrs. Mercy Cassandra, who's a principal associate with the Diamond Advocates and forms part of our Postal Secretariat Legal Department. She's very, very well versed with family law and will guide us on marriage and succession, which is a very important area that impacts us professionally, personally, and generally, I should say. So this session here is very, very important. The topic of today we shall be diving into family law and focusing on marriage and succession. We believe that this will be able to empower us and make us understand our rights and obligations regarding marriage, regarding family property, and succession as guided by the laws of Uganda. Without taking a lot of minutes, because our guest speaker is on call, allow me at this point to hand over to Miss Masika Sandra to take us through this enticing topic. Sandra, if you're there, kindly take on. Thank you.
Thank you, sir. Thank you, sir. For starters, I heard you address me as Mrs. Well, since the topic is about marriage, I think it would also be important to correct you that I'm actually still a Miss, not yet a Mrs. You know?
Wow, Miss
Yeah.
Sandra. Right.
Yeah. Thank you for giving me this opportunity, and thank you to everyone who has logged into this program. And I am honored to be given a platform to educate us about what we're going to hear today. Basically, it's about marriage and succession, but majority of it is going to be about succession. Well, why is this topic so important? Um, First of all, marriage and succession are they impact every individual, and these areas of law ensure that our legal rights and responsibilities towards our families are protected. I know all of us really spend a lot of hours at our workplaces, but we also ought to have the legal awareness, and also we also ought to know about, simple things like how to prepare documents like wills, marriage contracts. Because these documents, this knowledge will help to safeguard our legacies and also protect our children and any loved ones out there. And also, protect our properties because we really work so hard for these properties. They shouldn't really go to waste, when we are no more, right? Okay. So basically, like I've already told you, I'll focus on succession, mainly wills, dying intestate, dying testate. Dying intestate means dying without a will. Dying testate means dying with a will. Dying when you have already made a will. Okay. So, brief overview of the succession law. What is succession law generally? Well, this law governs the distribution of a person's property after their death. Some people always feel like they always fear making wills because they feel like there's this propaganda that when you make a will, somehow it's like as if you're going to die, but it's not true. And this topic, this opportunity came at the right time. Well, for me, why? Because over the weekend, I literally have appointments with some clients to to draft some wills for them. And I've already told them to come with all their certificates of title, all the names of their children, whether legitimate or illegitimate, so that I can come up with wills for them. Well, seems like God had it in plan that I would be here to teach us more about these wills, since I was going to, draft one over the weekend. Well, like I'd already said, succession law governs the distribution of a person's property after their death. I'd already said that there are different types of succession. There's tested succession and intested. When you die with when you die with a will, when you die when you had if you die after you had already made a will, then that is tested succession. Why? Because there's a will already. But if you die before you make a will, then that's an intested succession. And the laws applicable for some of these, the succession law, we have the Constitution of Uganda, that is the 1995 Constitution, Succession Act, and then the Administrator General's Act. Okay, so let's start with the tested succession. Like I'd already said, this is where a person dies after leaving a will or a valid testamentary disposition. Well, what is a will? That would be the next question. A will could be defined as a written legal document that states what property you own and how you would like it to be divided after your death. It also states it's also a form of declaration in a prescribed form of the intention of the person making it, or the matters he or she wishes to take effect, or after his wishes to take effect upon his death. It also, in this will, someone could also appoint someone who will be in charge of dividing the property. Okay, now who is supposed to make a will? Not everyone is supposed to make a will. For one to make a will, first of all, you must be of sound mind. Sound mind means that you must not be drunk. Sound mind means that your brain must be working. You must be able to think about everything that you're talking about. Also, minors cannot make wills. But there are exceptions to the sound mind principle. There's some people who are usually they have how would I call them? They have moments where they are of sound mind and moments when they're not of sound mind, like they're sober, like say for an hour, and then in the next 2 hours they're not sober. Such a person can still make a will, as long as at the time they're making that will, they are in their sound mind. But if someone is totally of unsound mind and they have medical evidence for that, they're not supposed to make a will. Okay. Also, a will can be altered by a maker during their time, but they can do so through an instrument called a codicil. What is a codicil? A codicil is an instrument that alters the contents of a will. Say today I can make a will, then I say, oh, wait a minute, I think I wrote something wrong in my will. Okay, let me write another one. That other will that is written is what they call a codicil. Okay, so when writing a will, there are some requirements and contents that it should have. First of all, a will must be in writing for it to be enforceable. If it's not in writing, it could also be in audio. We've had some people who have just recorded themselves, maybe on their phone or whatever, and that is it. But majorly it should be in writing. And then this will should the testator, what I mean by testator, a testator is someone who is making this will, the owner of the will. This testator should talk about, should show how his or her property should be dissolved upon his or her death, you know. And if he or she so wishes, they could also give expressions or views on variety of matters, maybe the conduct of persons who would ordinarily be expected to benefit from his will. He would also appoint executors and provide and providings for their functions. They can even say, on my function, I don't want people taking alcohol at my burial, you know. And also, they could also appoint guardians for their children who are infants. They could also make arrangements for payments of their debts. And this should generally, a will should, it's merely like a declaration of what you want. Okay, I owe this one money. This is what I want to happen on my burial ceremony. My children are still young. If I die when my children are still young, I would like my sister so and so, you name her, to take care of them. You know, these are my properties. This is my wife. If I have two wives, it's okay. If I'm married, write your status. If you're not married, you still write your status. So all those are, all that is what contains makes a will, should be in writing. And then this will should be signed by the person who's making it. When you make a will, you should sign it. Please, if you do not sign your will, then you have invalidated your will. And we shall talk about that later, because there's some wills that are made but are actually not valid. They are revocated. They are revoked. Sorry, they're revoked. Why? Because probably the person who was making the will probably did not talk about the children, or they did not appoint someone who distribute their property, that is an executor. Or they didn't distribute the properties in a fair way. You know, someone might have like 7 children, and then this person will decide to give property to only one child. The law does not provide for that. As long as these kids are legitimate, even the illegitimate kids, by the way, are entitled to property. We should know that, you know. So this does not mean that people should go out there starring kids. You know, the Bible does not ask for that for those who are Christians. But it's still, you know, still the law of justice still provides for them. If you have a kid out there, that child is entitled to that property. But the woman that you've had that child with is not entitled unless she is a legal wife. So, concubines, girlfriends who have kids will have no say. They'll have nothing to obtain from your estate if you die. But their kids, who are your illegitimate kids, will benefit from your estate upon your death. Okay, so this will must be signed by witnesses. The law provides that it should have at least not less than 2 witnesses. And then it should also be the testator, that is the owner of the will, must sign this will in the presence of witnesses, you know. And I think there's a bit of noise in the background. Can we please mute?
Elias, kindly.
Okay, so the testator must sign this will in the presence of the witnesses. But then at the time of signing, these witnesses are not allowed to see what is in this will. All they do is just sign where their name is, where they're supposed to sign, but they're not supposed to see the contents of the will. You see, you should also take note of that. Okay, so what invalidates a will? What invalidates a will? If there is coercion, or if there's forgery, or undue influence, if there's a mistake, or a mistake, basically coercion, forgery, undue influence, and mistake. Sometimes we've had people who have forged people's wills. Sometimes people have made wills, and probably because the father is around checking what they're writing, or probably because the spouse or the wife is probably around the corners checking what this person is writing, they give out properties to people they shouldn't have given properties to. Why? Because probably some other person that probably they fear is watching them. That is the undue influence. Mistake too, you know. All those are the vitiating factors that affect the validity of a will. Okay, so wills once made are liable to change by their maker, either through alteration, revocation, or revival. You can choose to alter your will, like I've already told you. There's a codicil. You can choose to revoke it. You can choose to revive it. You know. Okay, so we have generally talked about what a will is. Can we please have a copy of a sample of a will? Mr. Mkalere, I think we had got a sample of how a will roughly looks like. And I would ask one of us to at least, quickly read the contents of a will. When you read these contents, you're going to understand and comprehend everything that I've been telling you about. So can we have a volunteer? I don't want to read it myself because I already know what the contents are. I need someone to volunteer and read this for us to understand better.
Hello.
Oh.
Yes.
Good evening.
Favako.
Good evening.
Mm.
We have will format. The Succession Act Cap 162 as amended by the Succession Amendment Act number 3, 2022. Last will of, there is a space, name, I, thus give the names of this address, this day of the month, then the year. Make and declare this my last will, brackets, and revoke all former wills, or make this codicil in addition to my former will. 1. I have the following children. 2. My wife, brackets S, husband, stroke, I am unnamed, unmarried. Number 3, I have the following dependents, space. Number 4, I possess the following properties, brackets, land, shares, vehicles, bank accounts, etc. Description of property. Number 5, the following properties I give to my children. 1, you describe or description of property. 4, names. Roman 2, description for names. Then for my minor children, in brackets if applicable, I make the following provision. 1, description of property for the names. 2, description for the names. A, I appoint names of, and in brackets the address, to be the guardian of my children. He or she shall be responsible for their proper education and upbringing. B, I give my dependents, stroke relatives, the following property. In brackets, description of the property. C, my property acts, I give to my wife, dash, the names. I give my residential house to my wife, stroke husband, until her or his death. Thank you for listening.
There's another page. Well, I think the person, am I being heard?
Yes, you're clear.
I think the madam who was reading didn't see this page. Well, there's also another you appoint here.
Can I read it?
Okay, please do. Please do.
Okay. Number 6, I appoint dash names of address to be the executor or executors of my will. The next is I direct that my remains be buried at a place. Give proper guidance. I owe people listed below the money mentioned and direct repayment from account dash dash at dash dash bank. That is to say, dash dash names of address and the amount, and also another person names, address, and the amount. The following people owe me the money mentioned, and I direct collection of that money. Names of dash dash address and the amount, and then another person, address, and amount. I, however, forgive the following who are indebted to me. One, name of dash dash and the address and the amount, dated at dash dash, the place and the day of the month and the year, first above mentioned. Signed by the said, the names of then the testator. Signature or thumb mark, the testator, attestation of the witness in presence of the names of the witnesses, in presence of names of witness. NB. The testator and witnesses must sign or thumb mark on each and every page of the will as required by the new law. The testator shall not distribute in a will the principal residential holding and other residential holdings. The testator shall provide for the spouse, lineal descendants, and dependent relatives in the will prepared by the Administrator General's office.
Yes.
That's the end, I believe.
Yeah. So I believe you can now comprehend everything that I was talking about, you know? Literally everything that I talked about briefly is summarized in that will. What makes a will invalid? No executor is appointed. If no executor is appointed, it's not signed by the executor himself, there are no witnesses, and the witnesses should be at least two, not less than two witnesses. Okay, so now let us now talk about intestate succession. Remember, I had said that intestate succession is when one dies without a will. Also, intestate succession could occur where a person's attempt to die tested fails upon the invalidation or revocation of his will. That's what I talked about. You make a mistake in your will, you do not sign it, there are no witnesses, you do not provide for the beneficiaries, you do not have witnesses, at least two of them, that will automatically becomes invalid. So in that scenario, if this person dies, what happens? This person, first of all, since the will is not valid, automatically this person will the procedure taken will be as if one died without a will. Although, and that would mean that the process will be treated as if one died without a will. And the people who are processing the representative automatically would have to appoint an administrator. But the exception is they could choose to attach that will to their application. Why? Because that will could contain some of the wishes of the dead that the law still respects. Just because my will is invalid does not mean that you should not do what I wanted to be done upon my death. But then that does not mean that that my will automatically be valid. By a matter of fact that it's invalid, That means that it cannot be, you cannot go the other side. We cannot use this other leeway of appointing an executor, because probably didn't appoint an executor, but it can just be attached on another application made when one dies intestate. Can just be attached just to fulfill the wishes of the deceased. Okay. So the rules of intestacy determine the question of who is entitled to the property of the estate of the intestate. Intestacy may be total or partial. It is total where the intestate has left no valid will whatsoever. It is partial where a person fails to include his property or his otherwise valid will, or part of his will is declared invalid, like I'd already talked to you about, basically that. So the intestacy wills only benefit people who have a direct blood link with the intestate apart from the spouses. It does not confer benefit on such categories as unmarried partners or parents-in-law. To benefit such persons, the deceased has to make a will. In other words, for one to benefit from an estate of someone who has died intestate, why do I sound like I'm reciting a poem? For one to benefit from such, you must be directly related to this person by blood. People who are like unmarried, you cannot benefit. Remember what I talked about? If you're just a girlfriend, you're just a concubine, and you have a kid, maybe your mother-in-law, your father-in-law, please do not think that you benefit from your daughter-in-law's property. Please do not think about that. Why? Because you're not related to them by blood. The only people who can benefit from that are the beneficiary, the sons, daughters of that person who has died, the spouse. That is the only exemption of someone who's not related by blood. The spouse, any legitimate or illegitimate children that is still in the sons and daughters, and any dependents. Well, these dependents must have been solely depending on the deceased before this deceased person died, before the deceased died. I hope we are all understanding. So, in the absence of blood relatives, the estate passes to the state. We've had scenarios where people have died and there's no one no one related to them. There's no one who can be recognized. They even make announcements, but now who's related to this person? There's no one. Automatically that estate passes to the state, unfortunately. You understand? So I remember when you were reading the will, we read something regarding to residential holdings. So Section 22 of the Succession Act, Cap 268, provides for devolution of residential holdings. The residential holding normally occupied by the person dying intestate prior to his or her death as his or her principal residence, or owned by him or her as a principal residential holding, shall be held by his or her personal representative upon trust for his or her spouse or lineal descendants, subject to the rights of occupation and terms and conditions set out in the third schedule of that act. In other words, as long as you're appointed as an executor or administrator, actually that is the rule. This does not automatically become your property. You're just holding this property in form of a trust. So that means that you just have to take care of this property. And that includes the residential holdings. Let's say this person had a wife and children, and you've been appointed as the executor. All you'll do is just to, hold this house in form of trust for the spouse or linear descendants, the sons and what, all that. Now, basically, that is it. Now, any other residential holding possessed by the intestate or at his or her death shall be held by his or her personal representative upon trust and is subject to rights of occupation and terms and conditions set out in the third schedule. Upon the death of a surviving spouse, if the surviving spouse passes on, that principal holding and any other residential holding shall devolve to the linear descendants equally, who shall occupy it subject to terms and conditions set in that same act. So you get the sequence. Remember, we have said that no one benefits from an estate of someone who has died intestate if they're not related to that person by blood, except spouses. So even if the administrator is appointed, and probably this administrator is not a blood relative to this deceased or what, that person will still hold the property in form of a trust on behalf of the spouses and children. Ideally, and what usually happens is that the spouse and the children will still stay in this property because it is their property anyway. You understand? So when a spouse of the person who died intestate also dies, what happens? It is his or her children that take over that property. No one else will take that property. His or her children will take over that property. If those children die, it is their children that will take over that property. So that is how the sequence goes. That is how it moves. Okay. So any dispute arising, in case you get any dispute against, let's say, an administrator, you don't like the way they're distributing this property, well, you can try to protect you can try if you're really aggrieved, you can try to appeal to courts, and usually this is through, we say, plaints, and that is a civil procedure. Go and appear in courts and say the reasons why you feel you are displeased. There have been very many scenarios of this occurrence whereby administrators or executors have mismanaged the estates of people who are dead. My father said that when he dies, all the children should have a house. But when the executor was, distributing this property, guess what? No one has ever gained this property. He has never distributed according to what our father wanted. Or he only gave one property to, let's say, the favorite child. So I'm imagining I'm the one who's displeased. So I'm displeased with what the administrator is doing. How do I protect myself? I will go to court. I will file a suit. I will file a suit against the administrator. And probably even not even probably, when I file that suit, I'll also seek that the letters of administration or the grants of probate granted to that person should be revoked. Why? Because of mismanagement of the estate. Okay. So, okay. So, when distributing this property, we have a provision under the Succession Act which provides for distribution of this property on death of someone who dies intestate. It states that, subject to sections 25 and 26, the estate of the intestate, except for his or her principal residential holding or other residential holding, shall be divided among the following classes in the following manner. If he's survived by a spouse, a linear descendant, a dependent relatives, a customary heir or heirs, then the spouse shall receive 20%. I hope we are hearing very well. The spouse shall receive 20%. This is when the deceased dies intestate. Then the dependent relatives. Remember, I told you about the dependent relatives. These are the ones who were solely depending on the deceased. He was taking care of their education, their food, their everything. We have people we take care of in the village. You say, we have school fees. My kid wants to eat something. Literally everything they do, they depend. Everything they live for, you're the one who provides. Those ones qualify to be dependent relatives. So they'll receive 4%. Then the linear descendants shall receive 75%. Linear descendants are the children, that is, the sons and the daughters. Legitimate sons and the illegitimate sons, illegitimate daughters, and legitimate sons. Wait, legitimate daughters and illegitimate daughters. Okay, basically, I'm literally saying a lot. Both illegitimate and illegitimate children. Then we also have a customary heir, that is omusika. Omusika, that one will receive only 1% of the whole property. Now, sometimes omusika ali mu baana. Sometimes one of the children is a musika. Does that stop the musika from getting part of their 75%? No. Well, if you're lucky to be a child, you'll get your part, your portion from the 75%. But then you also get your 1% as a musika. That is what the law provides for. Also, where the intestate leaves no surviving spouse or dependent relative specified. Okay, specified in the ones we had talked about, where the intestate leaves no surviving spouse or dependent relative specified in that's above what I told you, capable of taking the property, then the linear descendants shall take 99%. If the person didn't have a wife that they left behind, then his children will take 99%. And then the musika, that is the customary heir, will take the 1%. But what about when the deceased, the intestate, is survived by a spouse, a dependent relative, and a customary heir, but no lineal descendants, but no children? This spouse shall receive 50%. The dependent relative shall receive 49%. The customary heir, like provided for before, shall receive 1%. Okay, another scenario where the intestate is survived by a customary heir, a spouse, and a dependent relative, but no linear descendants. The customary heir obviously receives 1%. Spouse or the dependent relatives, the spouse or dependent relative, as the case may be, shall receive 99%. I think I've already talked about this. Then where the intestate leaves no person surviving him at all, other than a customary heir, what happens? This estate shall be divided equally between the relatives nearest in kinship to the intestate. Are we hearing very well? Where the deceased dies and leaves no person surviving him other than omusika, the musika will just take the 1%, and the 99% shall be shared equally between the relatives nearest in kinship to the estate. Abechka. Okay. So I've briefly told you about all that. There's much more that is in regard to distribution of this property, but I just don't want to take a lot of time, I just don't want to take a lot of time, so let me go to there is also another provision for separated spouses. I don't know if most of us, I want to use this scenario. I believe most of us knew Semwanga Ivan and the issue of Zari. Remember when Zari was married to Diamond Platnumz? I hope the examples I'm using are familiar to all of us because these are celebrities in Uganda. I just want to use these celebrities for us to understand. Zari was with Ivan Semwanga. They separated, they divorced. They actually didn't, they were actually separated. And she was in, should I say, a subsisting marriage? Because I did not see any pictures with Diamond when they were married apart from them having children. But then they were in a separation. Separation is, it's also legally recognized. But then Ivan was on his sick bed. I remember during that time, Zari flew from Tanzania and came to the deathbed of Ivan Semwanga, despite the fact that they were separated. Do you know the secret? The secret is that a surviving spouse of an intestate shall not take any interest in the estate of the intestate if at the death of the intestate the surviving spouse was separated from the intestate as a member of the same household. Are you seeing the trick? I am married to my husband. We've been married for 10 years. Well, we get some issues. I decide to leave my house, to leave our house. I go and I stay alone. So we are separated. But then I hear that my husband is sick. Omusajja anaatera okufa. As a smart lawyer, my dear, I will go and take care of that husband, even when I have issues against him. Why? Because I'm trying to protect myself. If that man dies in my absence, I am not entitled to any of his property. Okay. So I know the things I'm telling you are really going to protect all of us. It's only lawyers that usually know these things. So I think that is the importance of this program. We get to learn some of these things free of charge. Okay. So who can apply? So we've talked about intestate and testate. So I'm going to go through the procedures of applying for letters for grant of probate and letters of administration. Remember, the grant of probate is provided when an executor has been mentioned in a will. That is tested succession. I'm hoping that we are understanding. Then the letters of administration are processed when that person who died did not leave a will. So that is the intestate. So I'm going to go systematically. I'm going to start with a grant of probate. Who qualifies to be an executor? Number one. First of all, for you to qualify as an executor in a will that has been made by a deceased, by the testator, you must be mentioned in that will. Court will majorly give you the grant of probate upon the application of that executor who was mentioned of that will. Court will just majorly ratify you as the executor, but the person who gives you the authority to be an executor is the testator. So what qualifies you as an executor is that you must be named in that will. Okay, and then these probates, the probates can only be granted to an executor who has been appointed by court, like I'd already said. And then the appointment of the executor may be express or by necessary implication. So sometimes people make mistakes when they're making wills. They say, oh, well, I want my executor to be omwana wange bambi mwagala nnyo alina emyaka ebiri. And then this person dies, ng'omwana we alina emyaka 16. The child is still a minor. Remember, legally, for one to qualify to be an adult, you must be 18 years. That's in Uganda. So, Section 180 of the Succession Act provides that probate shall not be granted to any person who is a minor or who has mental illness or unfit or improper person. Remember when I was discussing about who qualifies, or when I was discussing about who can make a will, the same rules apply to an executor. You cannot be given the authority to distribute someone's property when you are insane or when you're a child, because you do not think you're still a child. You don't know what you're doing. Or if you are unfit, you have a mental illness. So those are the issues that will, should I say issues? My English is betraying me. Those are the characteristics that would automatically disqualify one from being an executor. But also, we must know that actually several executors can also be appointed. It doesn't have to be one person, you know? So, several probates can be granted to several executors. I have a client, in his will, we are 4 executors. First, his best friend. Second, his spouse. Third, his brother. Fourth, me, who is lawyer. Why? Because he probably trusts his best friend. He trusts that the spouse will make sure that her kids get the properties that they're supposed to get. Then he knows that he trusts his brother. This is my brother, he cannot betray me. And then he knows that in case any of the 3 people betray me, my lawyer is there to protect me because she knows what is in the will and she has the authority to distribute this property. And that is how I come in. So we are 4 executors. Okay, so which courts have the jurisdiction to grant this probate? Well, High Court, according to section 231, and also the magistrates courts. But also this varies according to the value of the property. If you're rich, the High Court handles matters legally. The High Court, that is the jurisdiction of courts now. We're now in civil law, civil litigation. High Court handles matters that are above 50 million. Magistrates courts handles matters that are below 50 million. And still these magistrates courts are also in stages. There's a chief magistrate and there's also a magistrates court. Grade 1, chief magistrate will handle 25 million and above. Magistrate grade 1, chief magistrate will handle 50 million, from 20 to 50 million. The magistrate grade 1, not above 20 million. So depending on your estate, that's where you apply for your probates. Okay, so when you are appointed as an executor, what are your roles? What are your roles as an executor? As someone who has been appointed to take care of people's property by the deceased, first, you must locate the deceased's last valid will. You must also arrange the funeral, the deceased's funeral and burial. You must identify and collect all assets of the estate, both movable and immovable. You must safeguard, if necessary, investing these assets until distribution. They must be safe. Although there are some executors who really mismanage these properties, and that is a dismay, so disappointing. You must also pay off all the debts, the liabilities, funeral expenses, legal fees, taxes, and all that. You must file any appropriate returns, income tax, URSB, all those, You must distribute the remaining assets to the beneficiaries as per the instructions in the will. You must keep proper account of the estate. Then you must also act as a trustee of the estate. Remember what I said? When you are an executor, it doesn't mean that this property is yours. No, please, sir. You are just keeping this property or distributing it on behalf of the deceased, but it's not yours. We know the rightful people who own this property. Those who are related to these people by blood, that is linear descendants, exception of a spouse. So, okay, so that is for an executor. Now, when you have become an executor, how do you make sure that court appoints you as an executor? How do you make sure that court gives you the grants of probate, grants you the probate? First, you must have a death certificate of this person who died. You must also have a copy of the will of this person who died. Then you must also determine which court which court has the authority of this matter. Remember, I told you the larger the estate or the smaller the estate, usually dictate which court it's going to. High courts handle matters of 50 million and above. Chief magistrate, 50 million and below. Basically below 50 million. You understand? Okay. Then you must also obtain a letter of introduction from the chairperson. You must also have your national identity card. Please let us all work on our IDs in case they expired. Then you must also write court documents, petitions. Those are petitions. You must also commission your documents where necessary. Then you apply for this grant of probate. You must also publish. You have to notify the people that Munang, I'm applying to be an executor, and this has to be in the newspapers. Then you will appear in court for identification, that is before the magistrate or the judge. Basically, the magistrate wants to get to know who is this person who is going to be taking care of the property of this person who died. They want to see your face. They want to see your identification. They want to see your LC1 letter. They want to prove that indeed the person who's going to take care of this estate is of sound mind. Really, they want to deem it fit that you are able to take care of this property. And that's the reason for you to appear before court for identification. Upon that, if the court finds you, deems you fit, have all the documentation, then you receive the grant. After that, then you're supposed to distribute this estate. But it does not stop there, my dears. After you have been granted these letters, you must file an inventory. And this is usually after 6 months. What is an inventory? You have to state that on this day I was appointed as an executor, and just as I had been instructed, I distributed these properties like this. I gave this property to this one. I paid this loan. I filed returns. You're basically showing that you didn't get your probate, and then you didn't go back home and then start eating chicken and then start selling properties. You show accountability of what you did. Okay, so that is for one who's an executor. But then there's this other person who died, like we had said, without a will. That means that an administrator has to be appointed. So, first of all, for letters of administration to be applied for, it must be an intestate succession. For the person who is at the PowerPoint, can you please go to the part of letters of administration? The audience needs to follow what I'm saying. Okay, so for letters of administration to be applied for, first of all, this person should have died intestate. And probably, maybe there was a will, but this will became invalid. Remember what I told you? Maybe no executor was named, or witnesses did not sign, or even the testator himself did not sign. So as a result, that will became invalid. So automatically, you have to now go the other way. You have to appoint an administrator. So this administrator is appointed by court. Okay, and there are certain orders of priority for applying for letters of administration. First of all, the first priority is the widow or the widower of the deceased. Then the second is the child of the deceased, especially probably the customary heir, if probably the customary heir is among the children, Then any other person considered rightful according to the family And then a creditor of the deceased can also be appointed as an administrator. And then sometimes, remember when I told you that sometimes someone doesn't have a relative and their property will automatically go to the state? That means that the administrator will appoint himself as the administrator general will appoint himself as an administrator who will handle this property on behalf of the estate of the person, Okay. And also the administrator could also appoint himself if he realizes that the estate or that this family enough fujo. You go for a meeting before the administrator, you want to appoint administrator Nemulwan. You don't want this one to be appointed as the administrator. You don't want your mother-in-law. You don't want Simanyo Limoja, Wasimanyo no my stepmother, Wasimanyi Bichi. Administrator will just say, you know what? I'm not appointing anyone as an administrator. I'm going to appoint myself. Then I will distribute these properties according to how I deem it fit. Okay. So, what is the role of an administrator when an administrator is appointed? Literally, there's almost the same duties as the executor. Perform the funeral rites, make inventory, collect all property and debts of the deceased, pay funeral expenses, pay the debts, same. However, in intestacy, the distribution of assets is not based on a will, but rather on the rules of succession laid out in the relevant legislation. Remember the percentages I was telling you about? Those are the percentages they will, use to distribute the properties. Okay. Application procedure. First of all, when someone dies, it's common knowledge. You have to report the death to Administrator General. Then, when you report the death letter to NERA, you must get a death certificate. So, this is the death certificate that you take to the Administrator General and open up a file. When you open up a file, there are forms that you fill in together with the death certificate. You open up a file. You usually pay money for that file, plus even that form that you fill in at the Administrator General's office. The amount that you pay in that file is not even more than 5,000 Ugandan shillings. Then, this Administrator General will tell you, you know what? You need to call for family meeting. This family meeting will be attended by spouses, legal spouses, please, beneficiaries, children, dependents, And then, in this meeting, the family members will propose an administrator. They'll give names, and they could agree, okay, maybe let us make so and so administrators, or they could choose, let us make only one person an administrator. Well, after that has been made, then the Administrator General will make a report saying, well, on a meeting held on this day at my office, the members appointed Masika Sandra as the administrator of the estate of so and so. Now, the person who has been appointed as an administrator will apply for a document called a certificate of no objection. This is the document that he uses together with a petition and any other court documents to go and apply to court for letters of administration. This certificate of no objection usually given after some time, not really a long time, And then this administrator, together with this file, LC1 letters, we need the LC1 letters, certificate of no objection, identification, will go and open up a file and file a suit in court, a petition in the High Court or the Magistrates Court. Then, after filing this suit, this person will also have to go and advertise in the newspapers that my name is Masika Sandra. I was appointed as an administrator and I'm actually already applying. This is like a notice of application. I'm applying in court to be granted letters of administration. They're letting the world know so that in case there's someone out there that does not concede to that application, that person will have to file will have to file or lodge a caveat against the grant of those letters to court. So this advert runs for 14 days. After the 14 days have elapsed and no one has filed or lodged a caveat in court against or protesting that this person, this petitioner should not be given letters of administration, then it will be deemed that there's no one contesting against it. There's no one contesting. So this person will go ahead in court and appear before the magistrate or judge to be identified. Remember, just like the executor, they need to put to face and know this person that wants to distribute property of the person who died without a will. Like we had already said, this person will present their papers: national ID, LC1 letter, death certificate of the deceased, certificate of no objection, basically all information about them. Then the court will even ask them, do you know your duties as an administrator? These same questions are also asked to the executor, by the way. And this person will tell the judge, the court, that, you know what, yes, I know my duties. I'm supposed to distribute this property. I'm supposed to file an inventory after 6 months upon grant of my letters. Then, when the judge is satisfied with the presentation or identification of this administrator, the judge shall grant these letters of administration. Yes, and then after that, he shall file an inventory. So, like we had already said, the grant of letters of administration is by the High Court. If the property exceeds 50 million, the file is filed in the High Court. If the property value does not exceed 50 million, petition shall be filed in the Chief Magistrate's Court. So, all said and done, I think I have educated us a bit on the law of succession. Mind you, this is not all, but we, being time conscious, I've really tried to summarize most of the law of succession. So I want to open this this ground for any questions. I saw a question in the chat where someone said, can't grandchildren share on the property of their jaja? The answer is grandchildren are not entitled. But the jaja, these grandchildren can get entitled to this property if their father, who is a direct beneficiary of their jaja's property, dies, or their father could choose to give the property given to him by his father to his grandchildren, or the jaja could decide to bequeath. Oh, I didn't talk about bequeathing. Can decide to bequeath this property to his grandchildren. Well, let me talk about bequeathing. Sometimes we have people that we love so much, people that are not related to us, people that are our best friends, people that have made a great impact in our lives, people who paid our school fees and really believe these people deserve a gift from us. Or I'm a married man, but I have a girlfriend. Oh, I love her so much. I want to give her something. I don't care. What do? You bequeath. When you bequeath, you more or less giving like a gift to that person. And since this is a wish of the deceased, if the deceased gives a gift to someone, whether not related or not known, this wish shall be respected. Are we understanding? So, yes, grandchildren can get a share, maybe if they're bequeathed, or if their father, who inherited property from his father, dies, or the father could decide to give them their property. Tata wange yampea dinetaka mbundikoze se naye njagala ndibawe. I'm sorry, my Luganda is not really good. So that is how they can probably have a part of it. Yes. So basically, that is it. Someone is saying that now that technology is advancing very fast, there is hope that other media platforms other than newspapers shall ever be considered by courts of law for use relaying announcements to the public. Oh, unfortunate, my dear. The only places recognized as platforms of advertisements by courts of law currently are newspapers or the Uganda Gazette. Any other means, Simanyi radio, Simanyi Vici, not yet recognized. So much as the technology is improving, which is a very good thing, legally in Uganda, they only recognize the newspapers and the Uganda Gazette. Uganda Gazette is still under newspaper still because it's a gazette. Yeah. So can we receive any other questions? Thank you. Thank you so much. My name is Sandra Maskar. I'm a principal associate Diamond Advocates. We are your lawyers of Uganda Professional Science Teachers Union, and I sit in the legal department. We are located at Nakasero, Lodell Towers on the 5th floor. In case of any questions, any private questions, the IT manager, Mr. Mkalero Rogers, who can always avail my phone number, or you can always come to Appstu on Mondays or Thursdays, and I'll be available to handle any issues. But please take note that any private issues, that would have to be a private engagement. Thank you.
Wow, wow, wow. Very clear presentation on marriage and succession. I'm one of the people who have really benefited so much from this issue of how property can be shared among the family, and I think other members have also.
Is there something wrong with the moderator? I would think that anyone that has questions, please try to ask them.
Yeah, I think the moderator has dropped off. But yeah, maybe we can have one person to.
Sorry, I dropped. I don't know if we are still on.
Yes, Mr. Elliot, you're back. You can conclude.
I was appreciating the work done by our legal personnel, and we are really grateful and appreciative of the time and commitment she has given us in empowering us in this with this legal knowledge. We are very proud to have you with us. I don't know if there are members here on call who have some questions. Given that we already past 9, it's 23 minutes past. I don't know if there are some questions for our guest speaker today. If you're there, you can raise a hand or put it in the chat as we try to reach the climax of this session. Anyone?
If I may, I'm seeing this one of us, one of the lawyers with Diamond Advocates, called Ndijo, and I see he is online. I don't know if he's currently listening to me right now. I do recognize you, sir, and thank you for attending this session.
Mr. Ndijo, you're welcome.
Yeah, I think he has gone off. Yeah.
So one of I have a motivation I usually prefer, because I'm one of the people who likes having some legal knowledge. That knowledge of the law is the first step towards empowerment. Let's keep on learning, growing, and supporting one another. So, Miss Masika, really, we are so much grateful
Maybe
for that. We are having, sorry?
Mr. Elliot,
Yes, please.
something small. I wanted to inquire. Maybe and just have this and then before we close. I know many people don't have wills, and I saw the procedure for letters of administration where the executor or the administrator, and I saw very many. The procedures are really going up to court. What? I wonder, do really families follow these things? Because
Oh my dear,
if
yes, they
someone,
do. They do.
just a small question, like in the villages there, if someone dies and he doesn't have any will, don't they just sit there? They know, okay, this is his first son, this is his wife. The family just sits there, they share. Ah, I don't think I think many sometimes they don't even bother. Can government, but if the family doesn't bother to go into these legal guidelines and they just do things in their own way, what happens? Can government come in, or can someone? I don't know, but I think for me, I think many families don't follow all these procedures.
Yeah, surprisingly, many families actually do not follow such procedures, especially the families that have people who are a bit uneducated. But somehow, somewhere, they will always come and apply for those letters. You know why? Because some disputes will start coming up. Some people will start taking properties of their father, or they'll start fighting probably for some property, or someone will feel like they anyingirira nnyo ate nganda taka obe nyumba tata yatulekera fenna, and somehow they will always ask, and then they will always get knowledge that, you know what, you can always apply for these letters. So yes, most people do not follow these procedures, but also at a level of 100, I'll just put it at 50-50. But currently, and as it has always been, eventually they apply for those letters of administration in case of any disputes arising or in case of any fights within the family. Eventually they apply for the letters, because sometimes if their father or if their mother who died had money in the bank, they will not say, oh, you're the son or you're the what. No, 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 no. They will not recognize that. The only person they will recognize to withdraw that money from the bank account will be the representative, and that is either an administrator or so. Eventually, they always apply for those letters, or they always apply for those grants or probates. True, but also partly not true. Actually, partly true, but greatly false. They always apply for them eventually. You cannot access these bank accounts. You cannot access things they had in companies or in any shares, circles, unless you have powers to represent that person. Those powers are letters of administration or probate. So eventually you be coerced to apply for them in court. Yeah.
How are you?
Thank you so much for all that knowledge shared. I don't know if there is any other questions. We are heading to 9:30. If there is none, I would invite one of us to lead us into a prayer. There is a hand, Mr. Opus. Take on and ask your question. Mr. Opus. Opus, kindly unmute and talk.
Well, thank you so much, dear host. Mine is not a question, but to really appreciate our our legal team for giving us an eye-opener. In fact, this discussion has been very interesting. But my concern is just on attendance. When I look at my screen here, you realize there are only 13 people who have been in attendance. If possible, we could organize this at any other time and really see how everyone is brought on board. Because these are things that have always confused families in case of death, and there is a lot of confusion always. So if people are really given enough information concerning the issue of inheritance, administration, and the rest, I think such confusion wouldn't really take place in the family of science teachers. Otherwise, I want to thank you so much.
Yes, thank you for that observation. Sandra, do you intend to give us another dose of this so that we see?
Well, who am I again? I am we're your legal representative, so whatever you say we shall do. Because you are our bosses. As long as it aligns
Sure.
with our programs and our diaries, I'll be available. I'll be honored.
Yeah, the task we have as colleagues who always attend these sessions is to continue doing what we call mindset change of our colleagues. This link was shared in time, but of course, the colleagues seem to be very engaged. So we keep on educating them. And also, in case one misses out because of unavoidable circumstances, our YouTube channel is open for these sessions. They will be loaded there, and you can access them to have another bite anytime from now.
And
Mr.
actually,
Rogers.
I'm so
Yeah.
sorry.
It's okay.
Yeah,
It's okay.
maybe I want to make some small announcements. Madam Sandra, you can say your last word, then I say this small announcement just within 30 seconds before you close.
Sorry, I want to say that actually, much as I talked about the loan succession, to some extent, or larger extent, I didn't talk about marriages, and that would also be a very good topic to talk about. Some of us are staying with people thinking that our spouses. Some of us are staying with people thinking that they are our spouses, when in actual sense, we are just enjoying conjugal rights and just sharing kids. So, so it would really be good to learn about the different types of marriages and what qualifies you to be a married person. It's not just about telling someone to just come and stay in your house and then you start having sex and having kids and then you're staying for 12 years and then you think that you're married because your grandmother or your brothers know that person. No way. The Lord does not provide for that. So there are very many things we shall need to learn about, and I'm ready to educate all of us about that.
All right, thank you, Madam Sandra. And members, what I wanted to say, usually at the end of ProDev, we share some small updates. So the union is actively doing many activities, but one which is actually has been the Science Innovation Projects Competition. This project, this year, the union decided to take it on. And this Saturday, we are having our final regional exhibition in Northern Region at Lango College. So colleagues from Northern Uganda, especially those who are preparing learners, please keep time, and in case you are not there, you can go to our YouTube channel still. All the other three, the videos are there, how they went, the winners, and the union will be announcing the national competition when it will be due. And ProDev, we will always be here. So please always come on ProDev. You'll always get updates. So that's what I wanted to say. Mr. Eliud, over to you. conclude. Thank you.
Okay, thank you, Rogers, for that. Mr. Simo Herbert, are you on? If you're on, you can give us a brief closing prayer. Simo Herbert. Okelo Jacob, if you're on, you can give us a prayer. Oh, okay. I think maybe network issues. Colleagues who have attended today, thank you so much. We meet again on the next session of ProDev Hour next Thursday. The topic is being prepared, and I think it will also be very, very educative, like the one of today. I pray to God to give us a very peaceful night so that we wake up tomorrow in good health and able to glorify his name again. Thank you so much. I think we can declare this session closed. Have a good night all.